Welcome. This is the COVID-19 and the Law Colloquium, and I am Martha Minow, and with Emily Broad-Lieb, we developed this forum for discussion of the many ways in which legal rules and practices are tested and are responding to the challenges brought on by the pandemic. With thanks to John Manning and so many members of the Harvard Law School community for making this colloquium responsible, we are being recorded, though this live session is open just to our Harvard community, and we hope that there's an active period of questioning and discussion. The colloquium has addressed many topics, including basic human needs, government powers, and we'll be addressing, in addition, many others, but I don't think there's any topic that's more front of mind for many, many people than the one for today: elections, including early voting, absentee voting, fairness of voting, voting suppression, and so forth. And so I am very honored and thrilled to invite our terrific group here. Our moderator is the exceptional Charles Freed, colleague, beneficial professor here at Harvard Law School. He was the Solicitor General of the United States, Associate Justice of the Supreme Judicial Court of Massachusetts, and an expert on everything to do with the Constitution. He also is a founding board member of the Campaign Legal Center, a nonpartisan nonprofit organization using litigation and advocacy to defend a transparent, accountable, inclusive democracy. I confess I am on the board as well and grateful to be so. And Charles will be moderating with our two exceptional colleagues who are experts, leading national experts on the field of election law. Nicholas Stephanopoulos, whose research interests include election law, constitutional law, administrative law, is particularly an expert on the intersections of democratic theory, empirical political science, and the American electoral system. And he is an active commentator on these issues as well as a participant in litigation. He's been recognized by many groups for his critical work, including Chicago's 40 under 40 listed by the National Law Journal. Ruth Greenwood is the founder of our Voting Rights Litigation Advocacy Clinic here at Harvard Law School, which brings to this campus the possibility and important work of advocacy around partisan gerrymandering and protecting minority voters. Ruth also teaches the Voting Rights Litigation and Advocacy Workshop, and Ruth too has been recognized with awards, including an Exceptional Service Award by the Chicago Board of Elections for her work there. And so with no further ado, I turn it to Charles. Thank you.
It's a great pleasure to be moderating a session where Nick and Ruth present. I should say, the point of intersection with them. Ruth and Nick and I were all involved in the wars regarding partisan gerrymandering in Wisconsin. And this seemed absolutely the make or break case, because there had always been some ambiguity about whether this really was partisan gerrymandering. If it was, how much was too much, and all of that. And the litigation, the factual basis, was laid in Wisconsin such that the court could no longer continue to duck the question, because the partisan gerrymander was there. It was shown to be palpable. It was as clear as could be. And so all that was left was for the court to finally bite the bullet. Well, I weep to report that the court, 5-4, did bite the bullet, or at least broke our back by saying, in a sense, that anything goes. And the reason anything goes is because you can't say how much is too much, and only until you can say how much is too much can you draw a constitutional line. Of course, that's nonsense, and it's partisan nonsense, and it runs against the grain of so many constitutional doctrines where matters of degree become differences of kind, but it was ominous to the final degree because it suggests that there is no appetite in the Supreme Court to protect democratic elections. And if you had some doubt about that, you might cast your mind back to the other disastrous case, which was the Shelby County, Holder against Shelby County, which essentially got rid of Section 5 of the Voting Rights Act. As to that, the Ruth Bader Ginsburg of blessed memory said that this was like taking down your umbrella in a rainstorm because so far you've kept dry. And that's what happened. And we saw the result in 2014, in 2016, in 2018, where there was voting suppression all over the place. So we are at a crucial moment. I hope everybody watched the debate last night, because the only thing that it made me feel was that we were watching the action of the Prince of Darkness, the Prince of Lies. The president was nothing short of satanic. Well, there we are. On the other hand, we are lucky. We live in a state, and there are several such states, where there is a reasonable governor and a reasonable government which has done reasonable things, reaching reasonable balances, always in good faith. So good faith and reason do obtain somewhere. Whether they will prevail is by no means certain. With that cheerful thought, I turn things over to Nick.
Thank you very much, Charles, for that introduction. Thank you also to Martha and to Emily for organizing this terrific colloquium and for inviting Ruth and me to participate today. I'll note that I share Charles's views about the Supreme Court's recent election law decisions, including but not limited to Rucho and Whitford and Shelby County. I'll just note that one comparative bright spot in the litigation landscape that I'll talk about today is that the Supreme Court so far hasn't been the lead player. There are so many cases in so many places involving so many issues that it's not feasible for the Supreme Court to get involved very much. And so there have been a lot more victories than you might expect for plaintiffs, in substantial part because they haven't had to win in front of the Supreme Court in most of the cases so far. So the way that Ruth and I are dividing up this topic of COVID-related election litigation is by having me lead off and talk about the global landscape, what's going on in broad strokes across the country. And then Ruth will zoom in on a couple of COVID-related election cases that she's been litigating over the past few months. And so we hope that this combination will give you a nice complementary set of perspectives, a sort of high-level academic overview, and also the views of a lawyer who's been active fighting in the trenches in these COVID-related election litigation wars. Let me share my screen and then I'll start in earnest. So the cases that I'll be talking about, COVID-related election disputes, are extremely large in number. Stanford's Healthy Elections Project maintains a COVID-related election litigation tracker. And according to this tracker, more than 300 COVID-related election cases have been filed in more than 40 states over the last 6 months or so. There's always litigation in the buildup to a general election, but this year has seen by far the most pre-election litigation in American history. So we're in a remarkable legal environment heading into the election. These COVID-related election cases have addressed all kinds of election regulations. But the most common issues have involved how many polling places there will be, what voting procedures will be used in these polling places, what the deadlines will be for requesting absentee ballots and then returning absentee ballots, whether witness and notarization requirements for absentee ballots will be followed or relaxed or waived, and whether signature requirements for getting candidates or ballot measures onto the ballot will be followed or relaxed or waived. And just to give you a sense of the geographic scope of all this litigation, here's a map showing the lawsuits filed by just a single set of groups affiliated with the Democratic Party. You can see they filed cases in almost every single swing state. And they've actually achieved at least some success in most of the jurisdictions where they filed lawsuits. So let me talk first about what I'll call Category 1 litigation. This is the more common, the more conventional kind of COVID-related election litigation that we've seen this year. The typical lawsuit is a as-applied constitutional challenge to some election regulation, alleging that while the policy may usually be valid under normal non-pandemic circumstances, it's unconstitutional under the particular conditions of the pandemic. So this kind of a lawsuit is analyzed under a legal doctrine called Anderson-Burdick balancing, named after 2 Supreme Court cases where the doctrine originated. Charles may or may not have been Solicitor General when these cases were decided. I'm not sure. They were in the 1980s. Was not, okay.
John Anderson, yes.
Mm-hmm. Yes, John Anderson, yeah, post-1980 presidential campaign. So Anderson-Burdick balancing is a hybrid First Amendment Equal Protection Clause doctrine. And it's the crucial doctrine that protects the right to vote against burdens that aren't addressed by more specific constitutional amendments, like the 15th Amendment, the 19th, the 24th, and the 26th. So under Anderson-Burdick, the first question is how severe of a burden is imposed by a regulation on the right to vote, taking into account the number of people that are affected by a regulation and the nature of the impact, the nature of the imposition on each affected individual. Then the doctrine's most unique feature is that the level of judicial scrutiny varies in tandem with the burden on the right to vote. So a light burden on the franchise triggers something like rational basis review, a moderate burden triggers intermediate scrutiny, and a heavy burden, something like outright disenfranchisement, triggers strict scrutiny. And just note quickly here what a constitutionally odd doctrine this is. It's a system of sliding scale scrutiny that we don't see anywhere else in constitutional law. And it's also nominally an equal protection doctrine that's focused on the impact of regulations and is entirely unconcerned with the motives for regulations or the use or lack of use of suspect classifications. It's a very unusual equal protection doctrine. This is just a photo of Mark Elias. He's the Democrats' lead lawyer in dozens of these Anderson-Burdick cases. So what have the main issues been in these Anderson-Burdick cases? I'll just flag a few of these issues now, and Ruth and I can go into a lot more depth if folks are interested later. So one issue is whether an external circumstance like a pandemic is even relevant to the analysis of the burden that's imposed on voting. Some courts have said, no, you can't blame states for forces beyond their control, like a pandemic. So in these courts' view, the only relevant burdens are ones that can be traced directly to the four corners of a state statute. Most courts, though, have said that when analyzing burdens on voting, one ought to take into account the interaction of the challenge policy with external factors like people's socioeconomic status, their mobility, or whether there's some kind of exogenous shock, like a pandemic, also like a hurricane. Those external circumstances, in most courts' view, are part of the burden analysis. A second issue is how to think about election regulations that most people could comply with if they were sufficiently informed or motivated, but that some non-trivial number of people nevertheless won't comply with, being less informed or less motivated. And so most of the litigated policies fall into this bucket. Things like deadlines for requesting or returning absentee ballots, witness and notary requirements. They're irritating, but not impossible for most people to comply with. A third issue is how to think about the strength of the state's anti-fraud interest in this context. That's the typical justification offered by states for challenged election regulations. And so courts have had to think about how susceptible is absentee voting to fraud, and how conducive to stopping fraud are policies like witness and notary requirements, signature matching requirements, and the like. And a final issue that has come up in these cases is the so-called Purcell principle. This is a doctrine saying that courts should avoid changes to election regulations close to election day, because judicial intervention at this late hour can cause voter confusion. And so courts recently have had to think about, is Purcell an ironclad rule that has to be followed no matter what? Or might it be okay for courts sometimes to intervene close to election day if they try their best to minimize the resulting voter confusion? Or if the courts are trying to stop what would be significant disenfranchisement following from the status quo that they would be leaving on the books. So that's the first category of COVID-related election litigation. The second, less familiar, more controversial category involves lawsuits directed against states that have voluntarily chosen to make it easier to vote during the pandemic. So states like California, New Jersey, Nevada, Pennsylvania, and others have chosen on their own, without the threat of litigation, to make it easier to vote. They've done things like sending mail-in ballots to all registered voters, extending deadlines for requesting or returning mail-in ballots, and setting up lots of drop boxes where people can drop off their mail-in ballots without having to use the postal service. So one claim that's been brought against these policies is that they make it easier for election fraud to be committed because they include fewer safeguards against fraud. And so the logic here is that the fraudulent votes that are enabled by these overly lax policies then dilute the lawful votes that are cast by honest citizens. And supposedly this dilution of honestly cast non-fraudulent votes amounts to unconstitutional vote dilution. Another claim against these policies is that they cause too much geographic variation in how elections are administered, and thereby violate the principle the Supreme Court announced in Bush v. Gore. The logic here is that states like Nevada and Pennsylvania have required counties to set up at least a certain number of drop boxes, but they haven't barred counties from setting up more minimum number of drop boxes. And so allegedly there's impermissible variation from one place to another in the number of drop boxes that are available to voters. There's just an image of William Consovoy. He's one of President Trump's personal lawyers, and the Trump campaign has been the leading litigator in this category 2 of COVID-related election litigation, although other conservative groups have also filed similar suits. So one issue with these category 2 lawsuits is whether vote dilution via fraud is even a real cognizable constitutional claim. The court does recognize several species of vote dilution. Malapportionment is a kind of vote dilution. Racial vote dilution has been recognized since the 1970s. Partisan vote dilution is basically partisan gerrymandering, and it also was recognized for about 40 years until last year. But the court has never explicitly recognized a theory of vote dilution via fraud. The court has often noted that certain federal statutes prohibit certain kinds of election fraud, but saying that positive federal statutory law bars fraud is very, very different from saying that the Constitution itself prohibits statutes that are supposedly unduly conducive to fraud being committed. Second issue here is how to think about this fraud prevention argument when it's being deployed as a sword, not as a shield. So in the category 1 cases, the Anderson verdict cases, fraud prevention comes up when the state asserts fraud prevention as a justification for a policy that's being challenged. And so in that context, the courts usually don't require a lot of proof that the fraud is ongoing or that the challenge policy would prevent it. But note how in these cases, everything is inverted about the anti-fraud argument. The state isn't asserting the prevention of fraud, the plaintiffs are. The state doesn't think its policy will contribute to fraud, the plaintiffs do. And if the anti-fraud argument succeeds, the policy gets struck down, it doesn't get upheld. And so possibly this ought to mean, although courts haven't resolved this issue, that plaintiffs should have the burden of producing a lot more evidence about fraud when they're claiming that a policy ought to be struck down because it's unduly conducive to fraud. Last major issue here is whether a Bush v. Gore style claim about excessive geographic variation in election administration can ever succeed when there is variation, but it's all above a reasonable threshold. So in all the cases involving these claims, states have required that localities provide a reasonable number of voting opportunities, but they've also permitted localities to offer more than this threshold volume of voting opportunities. So if a Bush v. Gore claim could prevail on these facts, it would really strongly push our election systems toward centralized control and toward complete statewide uniformity, which might be a good or a bad thing, but it would be a radical change to our current system of decentralized variable election administration. Last thing, and then I'll end my presentation, is that the litigators and the political parties and the candidates think that all of these COVID-related election cases are really important. That's why they're bringing the cases and fighting against them with so much energy. I'm not as sure. So most of the litigation at the moment has focused on absentee voting. But the available empirical evidence shows that when states adopt mail-in voting, even on a universal level, where ballots are sent to every single person without their request, that has little effect on voter turnout and little effect on the parties' relative performances. And so if that's right, odds are that non-universal solicited mail-in ballots will have even less of an impact on turnout or one party or the other doing well. And note that that's all we're talking about. Virtually every swing state does not use universal mail-in voting. Virtually every swing state only sends out a mail-in ballot if a voter requests a mail-in ballot. And there's no reason based on available data to think that that policy will have significant electoral effects on the ground. And note that regardless, both sides in their official rhetoric claim to support solicited mail-in voting, where voters request the mail-in ballots before they get one. To link it back to the debate, which Martha and Charles both mentioned, even President Trump last night in his diatribe against mail-in voting said there was nothing wrong with solicited mail-in ballots. And solicited mail-in ballots are all that we're talking about in Pennsylvania, Michigan, Wisconsin, Ohio, North Carolina, Florida, Georgia, Virginia, et cetera. None of those places use universal mail-in ballots. So I'll stop there, but the last point here might just be that all this litigation over solicited mail-in ballots might be an area where the bark is worse than the bite, and where the ultimate partisan effects aren't that big either way. Thanks a lot.
Should I go, or do you want to jump?
You certainly should, Ruth.
Okay, hello everybody. As with many things, Nick is organized and clean and neat, like his office. I'm coming to you from another room in the house. I have kids' toys everywhere. I am scrambling down on the ground trying to do trials. Okay, I included in the materials for this seminar the work that I had done in Arkansas on ballot initiatives and COVID. I just want us to go back to March and remember, in the March 13, 14, 15, right? We've declared there's a global pandemic. We're all like, we're going to spend 2 weeks at home, maybe a month, and things are going to be okay. I get a call from I've been working with about 5 states on initiatives to put independent redistricting commissions on the ballot. This is in direct response to that delightful loss that Charles lovely reminds us of. You know, if the federal courts aren't going to police partisan gerrymandering, we're going to need independent commissions to actually establish the redistricting plans rather than letting the interested partisan actors do it. So in 2018, we had 5 successful reforms. I was like, great, 2020, let's see if we can get 8. There I am chatting with all these states. We've got these awesome ballot initiatives ready to go. Arkansas calls me up, or someone from Arkansas, and says, oh, we're supposed to be collecting our signatures right now. We're not going to be able to collect them for a couple of weeks. What can we do about it? And I was like, I mean, I don't know, a couple of weeks, let's think about it, right? And so then we talked about it and realized, you know, Anderson-Burdick was a ballot access case, right? It wasn't a right to vote case. It was about, you know, can I be on the ballot? So I was like, well, there's probably a colorable claim, right, under Anderson-Burdick. If you're missing out on a couple of weeks of gathering signatures, that's burdening some right. So I said, let's have a look into it and see what we can do. Now, other states who I was working with, Nebraska and Oklahoma, called up and said, that's it, we're done. There's no way we can collect signatures. We're not going to be able to do it. We're just cutting out. And then North Dakota also said, we think it's a problem, but we're going to try some trials. We'll see where we go, right? So we have these different responses. So we developed our case first in Arkansas. And in that case, there were some particularly interesting facts. So Bonnie Miller is about my age. She is with the League of Women Voters. She was like, yes, I'm doing the right thing. I'm staying home, but I'm not at otherwise high risk. I could wear masks and we can at the time, remember March, April, we were like sanitizing our mail and everyone had lots of hand sanitizers. So the thought was about how we were going to do that for gathering signatures. But she said, there are some people that really want to sign that aren't going to be able to sign. So one was an example of a woman who had been a city council member, very involved at Ella Gray, but she was in a retirement community that was on lockdown. They were like, nope, we're not letting anyone in. And I was like, how are you going to sign a ballot petition and nobody's going to be able to come in and witness your signature? And then I was like, well, what if somebody in there could get approved to witness your signature, but then they would need to find a notary, and then how are they going to interact with the notary without them also potentially exposing themselves to COVID, right? So that is problematic. We had somebody else who was undergoing chemotherapy and his doctor said he could see his doctors and his wife and no one else, same problem. But for Ms. Miller, she had all of these other people on her list that were League members that were going to go and circulate petitions. Now, I am a League member, so I say this fondly. Many of us are of an older generation and were very uninterested in walking around on the streets and interacting with people when COVID was around. So a whole stack of volunteers dropped out. So with all of those facts, I was like, well, let's think, what is the nature of the right here? In the burden on the right to vote cases, in the absentee ballot cases, it's, do I get to cast my ballot? There's a little bit of a question of, if you can't cast an absentee ballot, should you turn up in person, right, in those cases? But here, it was, if I can't sign this, is that a problem? And if I can't circulate these petitions, you know, is that a constitutional problem? I will say that naively, I thought, you know what, this could be one of those nonpartisan things. We could set some good law before all the absentee ballot cases come along, because there are ballot initiatives that are trying to do, you know, progressive things, and there are ballot initiatives trying to do conservative things. And so one of our aims at the beginning was to try to get 2 of them together and actually run the case together. Unfortunately, in Arkansas, there wasn't a conservative one on the ballot, and so it was just us. Anyway, so signing a ballot initiative is questionably actually something that doesn't get Anderson-Burdick scrutiny. Signing a ballot initiative in the Doe v. Reed Supreme Court case, there is evidence that you should just get exacting scrutiny. But we decided, we'll throw that in there. I don't think the court's going to go for it. In the 8th Circuit, it wasn't even clear that they really liked the Anderson-Burdick test. So I was like, that's all right, we're going hardcore on Anderson-Burdick. So for the rights of people to circulate the petitions, that really is an Anderson-Burdick thing. So we you know, go through and we explain all that. Now the 9th Circuit, there's a circuit split. They have a separate doctrine about basically having the right is to be on the ballot. I actually think that is not the right. And so when it became clear that there was going to be a circuit split and there was questions whether we should appeal up to the Supreme Court, we decided no. Anyway, so in the 8th Circuit, the right to circulate petitions, Anderson-Burdick applies. So that was, I think we had to litigate whether it applies. Now, once we have determined that, the question is to actually define the burden. And this, I think, is where this is something that is going to come up in all these other cases as well. the fact that the media around the country that people are ingesting is different has meant that it is hard to explain the nature of something to somebody who has already decided what they think it is, right? So when I said to you, this woman is in a retirement community, nobody's allowed in to sign, to have her sign, the judge hears, well, I mean, I know we're on lockdown, right? But I mean, I could just meet someone and like look at them through a window. And honestly, in the 8th Circuit decision, they said, couldn't you just sign something through a window from a distance? And I was like, well, what's the something that you're signing? Where is that transferring? Is there a hole in the window? Are we letting the coronavirus through the hole? But because these cases are decided on preliminary injunctions and TROs, you put in a couple of declarations, you have 3 days for briefing, and you go. And so you do have to rely on what the judge or judges know from their area. When I was looking up who my 8th Circuit panel was, I was trying to work out how the coronavirus was going in the states that they were from. So I would have a sense of how concerned they would be about it, which seems wrong from the perspective of court cases where you are supposed to bring the facts and then they, adjudicate on the facts. But I think that's the reality here. So we actually included, I think, in our North Dakota brief, what do they want us to do? Throw the pens at people? And then it became apparent that you could have single-use pens. So, and then there was can we walk up to a table and then walk away from the table and somebody else walks up to the table? Thinking through the actual logistics of this was a problem. Anyway, so my brilliant idea that this was going to be less controversial did not pan out. It actually turns out in the ballot initiative context, there has been not that much success across the board in getting relief. There's been relief at the district court level, sometimes even at the circuit, like the 9th Circuit, but then reversed by the Supreme Court in its shadow docket. So confusingly, in many of these places, despite the fact that there was coronavirus around, when they went and did trials, nobody in the states cared, right? So in Arkansas and North Dakota, they managed to get tens of thousands of signatures in the end anyway. Query how many of them got COVID. In fact, my co-counsel in the North Dakota case on Monday told me that he had COVID. Anyway, so that's, hopefully he's okay. So the nature of the burden, I think, has been discounted a lot in these cases, which means that if you look at the state interest, it's not that hard to build up a state interest in, maintaining the integrity of their process of putting something onto the ballot. The per-sale principle hasn't come in as much in the ballot initiative context, but we are right in the middle of that at the moment. I don't imagine anyone's getting last-minute changes. I could be wrong, but it's per-sale time. And then the other thing that I thought would be relevant, the thing that I'm thinking about, is most of these are brought as applied challenges, right? And the as applied is as applied because COVID is here. But many of the arguments that we make could really apply at any time. So the arguments I was making in Arkansas were, it is a real burden when you have to interact with a witness and then that person has to go and interact with a notary. In many other states, that is not required when you're signing a ballot petition. And so even though in the normal times, it's not so much of a burden, some of the language in our original district court decision said, there's this rigorous process through which everybody must, go and went through that. And my co-counsel there said, we might be able to use this next year to just bring a facial challenge and say, this is silly. We shouldn't have all of these, put up all of these requirements. I don't know that I think that that's going to work in the ballot initiative context, but it is interesting in the absentee context where the usual response from the state is, it's too much money. We couldn't do it safely. We can't do it without fraud. They did it this year. Could they do it next year? Could they do it later? My potentially silly example of this was, I believe I heard on the news that the city of Lowell was turned around from approving outdoor seating at restaurants from being a month application process to being 2 days. And one of the city council members said, why don't we always just make it 2 days? And I'm just interested in how the jurisprudence will go after these cases, if there is success, to then reframe how we think of burdens with respect to voting, because sometimes it's just lack of interest from election administrators in doing things differently. And is that really a burden? Is that really a state interest to just not change? So I think I'll leave it there. I know there are lots of questions and they're probably about things other than what I've talked about, so I'm happy to go into them.
Well, we have some questions here. do we have some questions? I wonder, I'm not so good at this yet. Thank you for joining us. 12:12. Here is a link. Our litigants, especially in the category 2 cases, providing any empirical data to support their claims of enhanced risk of fraud. A very important question, because this fraud argument really is the big elephant in the room, and it may be a pink elephant, which is transparent and non-existent. So how about that, Ruth? Has there been any proof of the fraud claim, or have the courts been rather permissive in allowing theoretical fraud claims, because maybe fraud does not announce itself as such, and only the possibility of fraud as imagined by a feverish imagination is sufficient?
Yeah, and I know that this is related to Nick's thing. I'm happy to let him answer, but I will say that the difference here is that in the past, when fraud has been raised, it has been raised by the state as an interest, as a defense, to say, we want to protect against fraud. We can't possibly do whatever you are asking us to do. In this second category of cases that Nick is talking about, it is claiming that your ability to get an absentee ballot is diluting my vote and making me experience some sort of fraud. And I think the short answer to Desi's question is no, I haven't seen much evidence at all. Much in the way that, Charles, you say there is not a lot of evidence on the other version, which is we need photo ID laws to protect us against impersonation fraud, which is non-existent. I haven't seen as much here. Nick, I don't know if you are going to give a more rosy view of the Trump litigation.
I'll just add one thing, which is that the district court in one of these big category 2 cases in Pennsylvania recently asked the Trump campaign to document all the fraud that they think has been going on, all the fraud that could be arising in response to laxer absentee voting rules. And the Trump campaign responded with basically nothing of any relevance. A 500-page document dump, largely consisting of news stories from conservative organizations about fraud at other times in American history or in other jurisdictions. There was stuff about Boss Tweed in the late 19th century in New York. There was stuff about Chicago in the 1960s. But actual evidence that the Pennsylvania laxer rules might result specifically in absentee voter fraud in Pennsylvania in 2020, there was virtually none. And I think, if this category 2 claim even exists, I think this evidentiary shortfall is likely to be a critical weakness for plaintiffs. If you can't prove that the supposedly lax laws are going to induce a lot of fraud, then all you have is hand waving and speculation, and that's basically what the courts confronted with these kinds of claims have said so far. When I was in category 1 and category 2, category 2 barely exists as a real category so far. It exists only in the forms of pleadings and complaints. No court decision so far has endorsed a category 2 claim.
Here is a question from Caitlin Rooney. Is there litigation against states for refusing to open mail-in ballots until Election Day, with a likely consequence that not all ballots will be able to be counted on Election Day?
My understanding is there isn't litigation on that yet, partly because it's hard to envision what that claim would be. That it is because it's like the right to count came up a bit, I guess, in Bush v. Gore, but the right to vote is not implicated by when those mail ballots are opened. So there could be a claim, I guess, if some are opened in one part of the state and not another, that raises that Bush v. Gore differential treatment. But we've never had a Bush v. Gore claim that one state is counting theirs for, doing one thing and another state is doing something else. So the way to get at that is through, you have to have, executive action, legislative change, or if it's something that could be done through the rules, working with the Secretary of State to actually, to change that.
From Taylor Dodson, what can guard against potential disruptions at polling places in real time? Wow.
So Nick and I have both done this, maybe me a little bit more. If you are trying to get things changed on election day, it is often too late. And this is why there's the 4 pillars lawsuits that the Democrats are doing and the Trump campaign is intervening everywhere. We have learned, I was doing election protection back in 2008 down in Virginia, and they gave me a phone number to call if there were problems, and I spent my day phone jammed, not able to get through to anyone because there were lots of problems. So the main remedy you can get on election day is let's extend the polling hours, right? Let's send out some robocalls to tell people the polling hours are extended. In terms of law enforcement or sort of poll watchers turning up at polling places, unfortunately, that is often something that is policed by the local election authorities. So I lived in Chicago and did a lot of work with the Chicago Board of Elections. They were fabulous. They would keep people away who would be intimidating. They were kind of ready to go. When I worked with the Democrats, the DNC in 2012 in New Hampshire, our response there was, we're not going to be able to get the authorities necessarily to step in and stop intimidation, but we can bring our own. And so somebody had the Teamsters guy come with everyone in their Teamsters jackets and turn up and be like, oh, you've got some intimidators? Well, we're here too to protect you. Now, to me, I don't really love that as a response, but it was what could be done at the time. I do think that the other question about these poll watchers that Trump is sort of inciting, there used to be the DNC versus RNC consent decree in place that had been around since the 1980s, and they had gone back to the court again and again when these sorts of stories came out, and have the court say you can't do these things. I think that, I don't know if it's been done yet, my guess is the DNC is going to try to file some kind of case like that to get it under judicial supervision, because that consent decree dissolved in around 2012. And then the last thing I will say is there are actions that you can take. Section 11B of the Voting Rights Act is an action against voter intimidation. Now, there is a private right of action there, so you don't have to rely on this DOJ, because I don't know that they would do anything. There's also the KKK Act, or the Enforcement Act of 1871, has what is now Section 1985(3), prevents conspiracy to intimidate or coerce people. And so back in the day, that was marauding hordes. There have been some cases by Protect Democracy. Some of the students might be in the Protect Democracy Clinic and have worked on these cases, where they were alleging back then that in 2016, the efforts by the Roger Stone and the Trump campaign to incite Russia to release the personal information of people at the DNC fell within voter intimidation and coercion. They actually said it was conspiracy to prevent supporters under the KKK Act. Those cases were not successful, but I think that if there were more extreme facts, there might be a chance for them to at least lead to sort of a TRO or a PI maybe.
Well, I think we have, for the moment, run out of questions, which must be a tribute to the fact that the presentation was so comprehensive and incredibly clear. Although I thought the last question about intimidation was really rather imaginative. Oh, here is a question from Audrey Robitaille. Professor Stephanopoulos, when you talk about the states voluntarily changing election laws, aren't most of those changes the result of emergency executive action and not the state legislature?
Yeah, great question. And so one of the claims that the Trump campaign made in these Category 2 lawsuits was that the policymaking itself violated the state structures in place for how election rules are supposed to be formulated. There would be a claim that a governor did something that the governor isn't authorized to do under the California or the New Jersey Constitution or what have you. That claim, unlike the Bush v. Gore challenge or the vote dilution challenge, certainly might have legs. It's a matter of state law, not federal law. But if a governor has usurped the legislature's authority, enacted policies that the governor doesn't have the authority to enact, that may well be a state constitutional problem. And so the response of the Democratic legislatures in California and Nevada was to simply, as in California and New Jersey, was simply to pass new laws that embrace the governor's action. And so by doing that, the legislatures were able to moot any challenge to the governor's authority, because now the governor isn't acting alone. Now we have a conventional statute that has been enacted through the normal lawmaking processes of the state. So it's a very good point that there's a potential state constitutional issue here, but legislatures were able to negate that issue by just adopting the governor's action as their own.
Well, if I can just ask a different question, that issue may interact with the issue of where governors institute lockdown or social distancing or masking requirements, almost all of which will not have been thought before and will almost never have been specifically authorized. And then the persons who object to these things might say, well, Governor, you have no right to do that. And I would think that's a very similar kind of objection to the one that you've just been discussing. How does that go? Do you have any notion about that?
I think that's exactly right. And so in the same way that a litigant might challenge a gubernatorial order regarding elections in the time of COVID, a litigant might also challenge a gubernatorial order that has nothing to do with elections, but that involves a lockdown, a quarantine, et cetera. And there have been such challenges. In Wisconsin, most notably, the Wisconsin Supreme Court ruled unconstitutional under the Wisconsin Constitution a series of lockdown, mask, quarantine orders that Governor Evers issued without the legislature's consent. And so I see these as parallel kinds of cases, both involving, yep.
Nick, do you think that the litigants in those kind of cases that I've mentioned are not innocent in the sense that they bring this kind of case to produce a negative answer, as they did in Wisconsin, because what they want to do is they want to preclude the governor in Wisconsin from bringing some kind of voter facilitation ruling also under the heading of the emergency. I think the same kinds of people, we see them on the street all the time. You meet them. I glare at people who do not wear masks, and I even say something, or I point to mine. And my favorite answer from people is, well, I've got a mask. I've got it in my pocket. I can't imagine anything so stupid. But there is a there is a kind of, damn it, nobody's going to tell me anything attitude, or I've been told what to do too much, which then would carry over and might include some of the same people who want to preclude the governor from easing the way to the ballot.
Yeah, I agree. It's certainly the same kinds of litigants, maybe many of whom have partisan, often institutional Republican or conservative affiliations who are bringing lawsuits, whether it's about elections or whether it's about other kinds of governor actions. I do think that the, damn it, leave me alone and let's get this economy running again motivation is sufficiently strong on its own to support the kind of litigation that Charles is talking about, even without planning several steps ahead to think about how that litigation might influence future litigation about electoral matters. I think in Wisconsin, I think the legislature would have happily challenged Evers's lockdown and quarantine measures, even if there was no possibility of Evers ever issuing an election-related order. They objected so strongly to the non-electoral orders that he issued.
Well, it's worth noting that Wisconsin is a state where you have a governor, a Democratic governor, who could not have been affected by the very powerful partisan gerrymandering and a very gerrymandering state legislature. So I think there are no innocent explanations here.
I agree, Charles. I agree. It is amazing that partisan gerrymandering has become a life or death issue, right? How states deal with the coronavirus is directly related to who's in the legislative offices, and that comes about because of partisan gerrymandering. It's terrible.
What do you think, asks somebody, of state legislatures circumventing popular vote and appointing their own electors post-election by citing unprecedented pandemic times, etc.? Wow, nightmare. Well, wake us up.
I think that's most likely illegal and unconstitutional. The state
On the first few bars, how?
Yeah. So the states have the background power under Article 2 state legislatures have background power to decide how a state's presidential electors will be allocated. Every state in the country has selected a popular election as the mode of allocation of the presidential electors. There are state statutes on the books already committing every single state to popular elections. The Supreme Court has said that, of course, when an election isn't ongoing already, if a state wanted to, it could change its mind and decide to use a non-popular election method for appointing electors. But that's only when an election isn't ongoing or isn't imminent. Once the election has begun, the state is barred by federal law from changing its method of allocating electors. And it also can't point to any Supreme Court decision that supports the state legislature's prerogative in that scenario. So the only circumstance that I can think of states successfully making an argument like this is if they can convince a court that the election that took place really was not a meaningful election because of extremely widespread fraud, or maybe because in the presence of a roaring plague, only a handful of voters showed up. But with any kind of meaningful election, the state is obligated by its own statutes to follow the results of that election when it allocates its electors. So I think this
how imminent is imminent?
Well, the election in every single state under federal law, ballots have already been sent out for the presidential election to military voters and overseas voters, at least. So everywhere in America, certain people already can vote in the presidential election and are voting in the presidential election. So, you know, I don't know how soon is too soon. I don't know what the exact threshold is, but after overseas and military voting has begun, I think it's plainly too late to change a state's policy for allocating electors.
What a relief.
Yeah.
I think we are reaching our closing moment, and I want to give my deep, deep thanks to our distinguished panel and for the lively conversation. There is a blog where this recorded event will be available, as well as commentary, and students and others are welcome to offer their submitted blog posts, as are our wonderful panelists. And I'm very grateful to Ruth, Nick, and Charles. Thank you so much.
Thank you.
Thank you, everybody.